everyone. My name is Ken Burkaman, and I'm here to answer your questions about wills, powers, attorney, probate. So if you have questions, raise your hand. Don't say, well, I don't want to, as long as it's on that particular topic. So we're talking about mistakes sometimes, and sometimes people say to me, Kenny, why do I need to have a will? Doesn't everything go to my spouse, to my kids? I goes, well, that's not really doing planning. That's just either hoping that you'll never pass or you're punting it to them. Because if someone doesn't have a will and they have children, the whole process becomes much, much more expensive, much more complicated. So, let's say there's 3 kids, there's no will. That means they all have to agree upon who's going to be the administrator. But then the other ones have to sign what's called a renunciation of administration. They got to pay a fee, file and sign in front of a notary, then file it out with the county survey. Well, if someone doesn't sign, then there has to be, in some of our cases now, a complaint ought to show cause in the Superior Court, asking that the judge appoint that person as the administrator. Then the court schedules a court date in 2 months, and then it has to be sent out by certified and regular mail to everyone, and the process becomes much, much more expensive. Let's forget about complicated. Number 2, then the administrator has to be bonded. But kind of the more important thing is that when loved ones are grieving, you shouldn't give them one more thing. I'd say if you own a house and there's a basement and there was a leak or a drip, you wouldn't say, you know what, I'm not going to do anything about that. I'm just going to hope it goes away. And then, but when my kids get the house, let them worry about it. Because in a way, that's when people don't do any kind of planning. So let's think about who do you want to get your stuff, who you don't want to get your stuff, because it's your right to give people what you decide that you want. You don't have to treat your kids equally. If you want to give everything to the Yellow Dog Society, that's your right. So, more and more people are saying, you know what, my kids are already grown, I'm going to give it to my grandkids because my own kids haven't put away any money yet. Let's see. Some people, sometimes someone will say, listen, I love my spouse, but my spouse is probably going to have to go into a nursing home, and rather than leaving it to my spouse, I'd rather have it go to my kids and do things like that. So the whole idea is do planning now, and also, I mentioned this thing called a bond. If you have a will, it has to have the word saying no bond required, otherwise there has to be a bond. So, where I was talking with Joy Robinson a little about, how we've changed things in COVID, and actually we made things easier. Because the old way was someone would come into the lawyer's office, and the lawyer would take out one of these yellow pads and start writing stuff down. And then everyone's name was spelled wrong. Okay, then we went to, we had the client do it, but then the client, we couldn't read their handwriting. Now, people can, we send them a short form, they type up some things, they send it back. Occasionally, some of our more senior clients say, I'm not very good with the internet. It goes, oh, no problem. Do you have children or grandchildren? Yes. Okay. Why don't you call up your granddaughter who lives 2 towns over and say, hey, I want you to come over the next 2 weeks and visit for a little while. I'm going to give you $5,000 if you do it. And if your grandkid isn't going to come over and help you out, when you're paying them, you might say, okay, no problem. I'll give the money to someone else. So, let's see. Logistically, here's what most attorneys are doing to make it easier for you. They'll email you out this questionnaire, you type it up, you send it back. Attorney calls up and answers your questions, has some questions to you. Then the attorney prepares it. They'll email it to you. You look at it. If everything's good, it gets printed and it gets signed. Also, what we learned in COVID, when everything had to be closed except essential businesses, the UPS store was determined to be an essential business. They had notaries there, so it made it a lot easier because people would say to me, Ken, what are your Saturday hours? Saturday hours, listen, I'm doing charity running races on Saturday or going to the beach. I'm not coming in and putting a suit on a Saturday. You know, I want to enjoy some of my life. So, what are some of the things that the attorney's that you're gonna type in? Well, what's your name, your spouse's name. Okay, then, who's gonna be executor one, who's gonna be executor two? Not that complicated, right? Now, sometimes someone will say, oh, I would like to have my kids be joint executors. I go, that is a big mistake. I recommend against it. I said, here's the reason why. They could be twins living together, but that means both of them have to do everything. Both of them have to go to the surrogate's office. Both of them have to fill out all the papers. Both of them have to sign every check. Both of them have to sign all the things for the real estate and do everything. And those are for people who get along. Sometimes you get two people that don't agree. I had these two brothers that we had to eventually go to court because they couldn't agree upon what color the sky was. Brother number one said, sky is blue. The other one goes, sky is gray, you're stupid, you've always been stupid. And I remember how the judge said to these guys, he goes, fellas, why don't you guys go and have a cup of coffee downstairs and talk about fun stuff you did with your parents and on vacation, because you're really arguing over junk. You know, oh, he didn't say junk, he goes, over stuff that the money you're spending on what you're arguing is costing you more in court fees and legal fees. So, now, who should be the executor? Well, someone that can do the job. Being an executive, they don't have to have their MBA from Harvard, but kind of our rule of thumb is, can they speak English? Can they drive to the surrogate's office? Can they drive to the bank and do the job? You know, I'm not, sometimes like we'll update a will where we're just changing who the executor is because someone says, listen, my spouse doesn't drive, and it would be better instead of taking the spouse off, putting someone else. Sometimes there's a falling out between family members. Well, you want to get them off. So, you think about who can do the job, but they don't have to live in the United States. They don't have to be a family member. Every once in a while, someone will say, I'm leaving everything to charities. Will a bank, I'll just have the bank be the trustee. I go, bank's not going to be your the executor or the trustee because you don't have enough money. You don't have enough zeros. If you had 5 million, 10 million, 20 million, the trust company of New Jersey would love to have you as a customer. But if you just have the house and other stuff, an attorney can only be the executor if the person asks them to do it. Because there was a Supreme Court, opinion. Because back in the 70s, attorneys were just inserting their name in. Oh, my trusted attorney, and the court said, no, that's not how it's supposed to be. It should be someone who they already know, unless they say they don't have anyone else. Okay. And by the way, when I'm finished talking, my colleague Brandon is going to talk a little bit about some financial mistakes. But your will takes care of your assets that do not have a direct beneficiary. Certain assets pass directly by title. So an example is, if a house is owned husband and wife, automatically goes to the surviving spouse. The will can't change that. Bank accounts that are power of attorney, CDs that are joint tenants or payable upon debt, automatically go to the surviving person. The will can't change that. So now other assets pass by contract. IRA, 401k, life insurance, annuities, anything that has a direct beneficiary. The will can't change that. So sometimes it's a good idea to get a printout of that you double check, and then you get a printout, and because that's who you directly want to get it, no problem, you just put that in with the will. I was sitting down with these two clients. A dad who was only 60 years old passed away, and I asked them on these accounts, are you two the beneficiaries or no beneficiaries? They said, I don't know. Okay, well, but we can try to help you find out. But it's easier if people have direct beneficiaries. Sometimes that makes it easier. Okay, now you have a question, and you're the winner because you asked the first question, so you get the New Jersey State Bar Association book, Law Points for Senior Citizens, even though you're not a senior citizen.
I am.
Okay, I'm ready. Tell me what your question is.
My question is that why, okay, so if somebody doesn't have a will,
Yeah.
and there's a deed to a house that says it is joint tenant in common, why does that have to, why do I need to get a lawyer and have to have?
Okay, so the question deals with joint tenancy. Well, there's two different kinds. If it's joint tenancy, it automatically goes to survivor. If it says tenants in common, it's owned 50-50. Okay? Okay? But the other thing is that there's always some kind of asset that someone has that doesn't have joint. What about a car? It's very rare that two people own a car together. And after I talk about wills, by the way, I'm going to talk a little bit about power of attorney. Because for some people, the power of attorney while you're alive is more important than the will. I know. I'll touch upon that briefly now, since it's on my mind. Let's see. I'm married. Let's see. If a meteor struck me down, even if I didn't have a will, my wife gets everything anyway because the children are from our same relationship. But if I'm driving to New Brunswick in 49 minutes and some dumb kid who's looking at their phone goes through a light and creams the side of my car and my arm's broken, my wife doesn't have the legal authority to do anything for me. So that's the reason why some people should have a power of attorney. Actually, ironically, if I went into the bank and signed something, the bank people would say, who are you? You're not Ken Vercamer, that's not your signature, because my wife's been signing everything for 25 years. Okay, now, it's pretty easy, but if you pass, who's going to get your stuff? Let's say it's your decision. Mr. K hasn't been able to decide in 4 months. Mr. K, well, I'm still thinking about it. Okay, Mr. K, let me ask you a question. If you're going to pass tomorrow, and if you don't write it down now, do you want the United States government to get it? Yes or no? I don't want the government to get it. Well, think about that. Okay, and right now I said you don't have a will. Let's say that people you don't know are going to get your money because you don't have children. So that means that it's going to go to some distant cousins, everywhere. So that's why if someone doesn't have close family, they can give it to different charities. Okay. This man had a question, and I use an amazing Kreskin tool. His question was, can I get one of those books? What's your question, young man?
Yeah, so say I'm going to leave everything to my wife.
Yeah.
We go on vacation, we're in a plane.
Yeah.
Plane crash. I die right away. My wife lasts for maybe a week and then she dies.
So in the wills we do, we have a clause that says, provided they survive me by 30 days, if it's one of those car crash situations, or sometimes, you read stories that someone who's 99 years old, they pass away, and then their spouse dies, the next week because, the stress of everything. So you always want to have, if that person goes, who would get their share? People who grew up here in the 60s remember Leave It to Beaver, in black and white. So that was pretty, you know, when the ward passes, it goes to his wife, and if she passes, it goes to the 2 kids. But more and more, we have the Brady Bunch family where it's a blended family. And so sometimes what we do with that, we said, listen, I go, you know, it's kind of like the second marriage situation. I go, okay, I saw what you wrote that you typed up. You wanted to go to each other, and then you wanted to go to all your children from both sides equally. I goes, that's not a good way, we're gonna do it a different way. They go, why? He goes, well, do you realize that the day after you die, he can go out and have a new will that says, you know what, her kids aren't getting anything. Forget that. You know, because people have asked me that, you know. I said, instead what we can do is say, everything's gonna go to your spouse, but not to her. It's gonna go in what we call the testamentary trust within the will, and that way they're provided for. And then when she passes, then it gets divided. And also the other benefit of doing it that way is that money that's in this testamentary trust is protected from Medicaid, it's protected from taxes. Now remember, it's your right to do with your stuff what you want. One of our clients says, she goes, do I have to treat all my kids equally? You know, we said, yeah, you can give it all to the yellow dogs. You know, because my IBO lab that comes into the office. I go, what's your concern, ma'am? She goes, well, my one son lives on the West Coast and we don't hear from him much. Okay, well let me ask you a question. Did he send you a card or a call on Mother's Day, your birthday, or Christmas? She goes, nah. I goes, why would you leave anything to that bum? Because number one, he hasn't done anything to help you. How would he even know that you're not in the hospital now? And when you do pass, he's going to be the loudest person to say, where's my money? Give me my money. So I said, yeah, don't have to leave anything to him.
Can he still contest it and say that maybe his
An
parents
interesting question.
say his parents were coerced?
Can someone contest a will? Yeah, if they have money. So let me talk a little bit about people that want to contest the will. I totally don't call back later. My wife's supposed to. All right, so contesting a will requires a complaint order shall cause in the Superior Court. Anything in the Superior Court requires complaint order shall cause, and anyone that's in the will or anyone that would have inherited without the will must be served with the complaint by certified and regular mail and a proof of hearing. So there's a gentleman called me up, and he said, I wasn't left, anything in my dad's will. He goes, okay, the judge is going to ask you a couple easy questions eventually. How many times did you visit your dad in the past 2 years? Oh, we had a falling out. Okay. How many times did you call your dad in the past 2 years? Oh, we weren't talking. Okay. How many letters did you send to your dad? None. He goes, well, sir, you do not have a winner. Now, I mean, you could spend a big chunk of money and maybe they'll settle and give you something, but you're shelling out money out of your pocket to do it. Let's say another guy hired us to contest the will, and we subpoenaed the attorney's file that had prepared the will. And there was a letter in there that the mother had given to the attorney, and it was from the guy that hired me. The letter basically said, "You're nothing to me," I'd say, and you were a bad mother. Well, I go, sir, I think you should probably stop spending money on like that. He goes, you don't have a winner there. So again, contesting it, but so what we do, some people have specific bequests. What a specific bequest is where you're giving either a percentage of money to a person or charity, or an amount of money to a person or charity. So sometimes the ladies say, I would like to have my jewelry and my mother's jewelry go to, my daughter or my granddaughter, because I know my son, the executor, is going to go bring the cash for gold and say, what do you give me for this junk? Some of the men have, we're sportsmen and they have, hunting rifles or stuff, and they goes, I'm going to give it to someone that's going to use it because I know my daughter's going to, just call the police on the firearm and say, take it away, and the other stuff's going to go in the garbage can. Now, specific bequest. So sometimes we have the reverse specific bequest. I leave nothing to name a person. We don't leave them $1. We don't put a reason down because they know what the reason is. Now, there is a thing that's called undue influence. And there's case law on that. Undue influence is where someone exerts the control over the person. So, someone's old and can't get around, and all of a sudden there's a new will done. But it's very fact specific. That's why we will only do a document if we speak to the person and we're satisfied it's what they want. And I mentioned sometimes someone says, listen, I'm not good with computers, can I have so-and-so help me? Yeah, but I'm gonna need to, or sometimes we'll get the call from, the son, the daughter, yeah, but I need to talk. I need to talk to them before I draft anything, because I gotta make sure. When they come into the office, our office asks 3 easy questions. Did you read it? Does it contain what you want? And is anyone making you do this? Well, if someone comes into our office and says, no, I didn't, I remember one time, lady said, no, but my daughter did. Okay, you're coming in another day. We're not signing today. And then the daughter brought her in and goes, oh, she misunderstood. She did read the will. He goes, yeah, we know what we heard. And I'm not going to jeopardize my license where someone told my office, no, I didn't read it. Let's see. No. Our policy is we either can do it right or not do it at all. I'm not, again, I don't, just to make, some money, I always do it right. Now, that's, nothing to, we often set up, so I mentioned earlier, something called a testamentary trust. So, it's not one of these fancy trusts that costs $5,000 and there's a booklet and with tabs on. It's a couple clauses in the will. So, all the wills have a typically a clause. Anyone under 21 gotta wait until they're 21 to get the money outright, but it can be used for their support, maintenance, education. When there's minor children, we say they get some when they're 21, 25, and 30, but it can be used for college ahead of time. So I mentioned sometimes when there's it's a second marriage, or we don't want the spouse to get the money outright, testamentary trust for the spouse. Sometimes, there's a child or a grandchild that has issues. Let's see, the people who have special needs, children know they should have a special needs trust set up. But sometimes you get the kid that they could have alcohol problems. They're adults. Alcohol problems, drug problems, whatever kind of problems, or they just blow their money. We handled an estate where the mom had divided everything equally amongst the 4 kids, but the money for the one son went into a testamentary trust because he was an alcoholic, and you know, with alcoholics, whatever money they would get, they would run out and buy booze. So there was a motion filed in the Superior Court by his ex-wife saying, "Oh, he owes me alimony. I want the money." And I represented the estate, and I said, "Judge, the law is pretty clear that when it's a testamentary trust with the sole discretion of the trustee, if they don't want to give the person money ever, that's their right." And the judge who handles Somerset said, yeah, the case law is clear that way. So a couple of things to think about, you know. Yes, sir, in the back.
Along that same line, if you have a child who has a child, but you want to protect yourself in this day of divorces, and you know you have ample resources, but you want to help your son or your daughter, but you don't want
The divorced spouse.
Yes.
First of all, this man's wearing a President Cup shirt. I'll tell you, what year is that President's Cup shirt? 2008.
Yeah.
All right. Let's see. Because I probably ran it that because the President's Cup of Milburn back then had all the beer you could drink. Let's see, and I always got a designated driver. But I do remember one year my designated driver was before we had like GPSs, and we're trying to remember how we got there from Edison, and all of a sudden we're not going the right way, and we're lost in Irvington. So you got two Irish guys that drank too much. Anyway, so let's see, under divorce law in New Jersey, monies that you started before marriage don't count for what if there's a divorce and it's split up. Monies that you get by inheritance or by gift, those are not subject to equitable distribution. I'll say, now if someone inherits money and then they give it to their spouse, well, then they gave it to them. So sometimes what we did for someone that, you know, the family was really concerned. It was, okay, listen, here's what we're gonna do. You know, because you can't guarantee that both of you are gonna, you know, immediately is gonna start. Okay, we can set up a testamentary trust for your son, and let's say you have your oldest child is the second executor and the trustee, and if they do get divorced, and once the divorce is over, then you go, okay, here's the money. Well, otherwise, that's how we do this testamentary trust kind of thing. It's kind of like I tell people that, you know, don't have wills, but oh, my kids are pretty good. It goes, you have to protect them from their new friends, because the kid could be the valedictorian of the high school and they're doing great in college, and then all of a sudden there's no parents to kind of supervise them or follow up, and their new friends say, hey, guess who just got $500,000 cash? You know, say, let's go help them spend some money. You know, hey, let's go to Maloof. They go to Maloof and goes, hey, I just inherited $200,000. You're going to need $200,000 sports cars. And the salesman from Maloof's going to say, we only have one left. And there's that other guy's looking at it right now. I think you better put a bid on it. You know? So, I mean, if I would have got money when I was 19, I would have invested it wisely. I would have bought a red fast car and spent the summer in Seaside. Oh, I don't need to work. Let's see. Now, get your documents done. Don't be a Carl. What's a Carl? Carl was this retired, engineer, not a trained engineer. The ones that do smart stuff, right? But the problem with these people, they're too smart. They're the ones that when they'd buy a car and they would read the whole manual. or they would get the first couple of generation computers that had the Apple Mac manual was this thick, and they'd read through the whole thing. So I go through with Carl, some of the suggestions that we made. He goes, well, I like to read up on it. Carl, you don't need to read anything. I go, I already read for you. I went to law school, I passed the bar, I would go to seminars, I listen to law every day through the computer. I'm a speaker for the state bar and different things. I said, Carl, when I had my knee surgery, I didn't read up on it. I called the Rutgers track coach. Hey, who's the guy that's doing your fellow's knees? He goes, oh, the guy at University of Orthopedics. Okay, good. When he was doing the knee surgery, he started explaining stuff. I goes, just do the best you can. It's kind of grossing me out when you're talking about like drilling holes. With his minor children, by the way, we usually have a clause who would be their guardian 1 and guardian 2. And I've had young people go, they put it off for years. I can't really decide. There's no best person. Well, of course, there's no best person, but you understand that if you don't have it, a bald white guy in New Brunswick determines who's guardian. And you could have someone who would not be the right person. So what we did one time is we just wrote down a couple names on a piece of paper, and we moved them around, and it goes, okay, close your eyes and pick one. That, same thing with someone couldn't decide, which one of the kids was going to be the executive number 2. All right, close your eyes and just pick one. We did that in the Elks Bar. I have one of the other people there, because I'm a volunteer at the Edison Elks. But remember, who don't you want to get your stuff, who you do want to get your stuff. Let me touch upon the other common thing. My mother-in-law, who's going to be 91 years old, used to call me every year. I want to come in and get a trust done. I would ask her, were you watching Susie Orman on TV? She smiled. Oh, yes. I go, Susie, yeah, I see it. Susie Orman is so right if you live in New York, California, Florida. If you don't have a trust in like Florida, it's not only having it, but have your property owned, you're really screwing your family, because my father-in-law who owned a condo in Florida, I must have told him, 15 times, hey, you should put this condo in Florida. Don't tell me what to do. Okay, fine. So it costs $15,000 and took 3 years. But New Jersey's the probate easy estate. Trust salesmen that charge $5,000-$6,000 for doing all these trusts and doing the transfers say, oh, avoid probate. Probate's the devil. But the county surrogate goes, yeah, probate costs about $190, and it's usually done in less than a year. So probate in New Jersey is inexpensive, not that complicated. A revocable trust does not protect assets from nursing home. It doesn't protect them from taxes. If someone says, I do want to have a revocable trust, okay, that means that you're not going to own your assets anymore. It's going to be owned by the trust. So that means like the deed transfer. Doing a deed transfer is not like a car title, just signing in the back. It requires a new deed affidavit of title, seller's residency form, seller's affidavit, the county clerk's cover sheet, and a filing fee of about $150. Some people inquire about irrevocable trusts, which are the ones that people sometimes use to protect their assets in the event they have to go into a nursing home. Okay? Same thing. You're not going to own it anymore. The trust is going to own it like a separate thing. There's new titles, etc. The people that do it usually charge 10, 15 grand. Their pitch is a nursing home costs more than that. So if you're able to save the money and you're in a nursing home by 2 months, we just saved you 15 grand. Sometimes people ask me, goes, well, you didn't ask me. what do I do? What did I do? He goes, I'm putting my assets into what? And when you do this irrevocable trust, you're rendering yourself penniless. It's a 5-year look back. And when you're penniless, Medicaid is welfare. You go into the welfare nursing home. There's nice nursing homes, you know, newer ones, and the welfare one. And I said, listen, you know, I said to the client, he goes, I'm not going into it. Why should my son, Dr. Brendan, the dentist, have a bigger boat so I can go into the welfare nursing home? You know, I said, you know, listen, for any of you guys that worked hard when you were a teenager, I had a paper route, and I was shoveling snow, and I was always hustling for money, and I worked hard, and then I go, wait a minute, let's say, why would I want to make myself penniless? Because if I'm that sick and not well that I can't take care of myself, I can't walk, I'm going to go to the most expensive one. I'll pay for my own room, the chocolate comes on my pillow like at the Hilton, you know. So anyway, okay, tell me what your question is, ma'am.
My question is, did you just say in order to do a revocable trust, it's $10,000 to $15,000?
The attorneys, a revocable trust, people that charge usually about $5 grand. The ones that do irrevocable trusts are usually charging 12 to 15 grand. You know, so, you know, they're, because you know, someone says, I want to do it, you have to have certain knowledge of the federal Medicaid law, and since the law was about 1,000 pages long, I goes, listen, let me, you know, I'll do stuff that I'm smart, comfortable doing, but guessing is always wrong. So they charge a ton of money.
All right, one other question, piggybacking on that. You said probate in New Jersey is not expensive, but that's now. We don't know what it might be in maybe 10 years, or has it been that
New Jersey, believe it or not, New Jersey reduced some taxes. They did away with the New Jersey estate tax. For inheritance tax, there's no tax that is going to children, stepchildren, spouse, grandchildren. There is a federal estate tax. That's, Brandon, that's like $12.7 million, right? Okay, everyone in this room that has more than $12.7 million, raise your hand so we can all stare at you. Nobody. Let's see. You know, I'll tell you something about money. I'll tell you. There was a study that says for people that win more than $1 million in a lottery, something happens to 99% of the people. They gain weight because now all of a sudden they're eating out, and people are a little frugal, and like, let's eat now, and let's have. My wife and I, putting kids through school, they goes, would you like some appetizers? Nah. I'd say, would you like to have some dessert? No. Now that the kids are out, yay! There was this great movie that Morgan Freeman was in, Alan Arkin, and the English guy, and they'd go to the diner, and they would never, the one guy, the waitress goes, would you like your cheesecake? No, I gotta cut back. Cut back? Yeah, our pension's being cut, so they decided to rob the bank. Okay, you had a question. And the bad news is I gave out all the books, but, okay.
Yeah, so I have a couple questions. One is, I know you were talking about the irrevocable trust versus revocable trust, and it seems like it's not favorable in New Jersey.
Well, in New Jersey.
But, just out of curiosity, if you had a house and someone put it in a revocable trust, can someone actually, who does have access to the trust, should I say?
Well,
Because
the
you're
person,
saying
while you're
that
alive,
it's penniless.
while you're alive, you're the trustee, but that doesn't protect you from Medicaid. The only thing this revocable trust is if you passed away on October 5th at 6:40, at 6:41, the trustee can go and sell the house. As soon as the person's dead. Probating the will takes 10 days, but it's usually no big thing. So I always ask people that ask me about trust, why do you think you need to have a trust other than you watched Susie Orman or someone on TV, and oftentimes it's, well, my friend has one. Where do they live? They live in South Carolina. Where do they live? They live in Florida or whatever. Let's see. Good.
Well, I was just gonna say, so like say for instance, someone sets up a revocable trust, and they live 10 years, who owns the trust?
That person is the trustee.
So even though they're
So
penniless,
if you,
they're-
but the trust owns it. But because they own it, they're not penniless because they still have control over the trust. So if it wants to be protected, it gotta be, someone else has to be the trustee with an irrevocable trust. Ma'am, you had a question?
Earlier, you said if you have a will, you have to pay a bond.
No, if there's no will, if there's no will, the administrator has to take out a bond. If you do have a will, make sure there's a clause in the will that says no bond is required. So I did one of the seminars. One of the speakers was the county surrogate, and they said they see the big problems are when people try to do their own stuff and they do it wrong, or they don't sign it right, and then they have to go through the whole complaint order show cause thing. On the other hand, sometimes these cheap things online that doesn't have the magic words, no bond is required, so then you got to spend a couple grand doing this bond. One of the things the surrogate said, she goes, I'm not an attorney, but one of the things that you're buying with an attorney is typically someone that's knowledgeable and independent witnesses. So someone talked about in the back, asked me about undue influence. Well, we only sign something if we're pretty sure it's what they want. Undue influence sometimes is where, when was the will done? Well, Dad was in the hospital and the one daughter had it prepared on her computer and said, Dad, sign here, and had two of her friends as the witness. You know what you say? That smells. And you know what? If something smells early on, it doesn't get any better. Let's see. Oh, that fish is going to get smell better by tomorrow. No, it won't. Sir, you have a question.
What's the advantage of a trust versus a will? What's the advantage of a will versus a trust? Two questions.
Well, I already went through the will thing and I discussed the trust. I asked people, why do they think they need to spend anywhere between 5 and 15 grand on a trust? Some people say, I want to guarantee that my kids get my assets, so I'm going to put it into an irrevocable trust. The problem is they still got to live 5 years anyway. Okay, listen, I went over my time with the power of attorney portion. Oh, by the way, some people through their business, where they work, they have wills covered to be prepared. Those are called legal plans. So Johnson & Johnson, for example, has one through Arag Legal, MetLife Legal, Legalese. And by the way, if anyone attends our program, typically we charge a consult fee, but we don't charge a consult fee if someone contacts us within 30 days. You had a quick question.
Just a real quick question, because I know you're moving on from
Yeah.
trust. But in this
trust is done
template
with.
here, it says that if an example of the New Jersey estate tax. So it seems like there is an estate tax But you're saying
Yeah,
that
that's,
New
what you got there was printed prior to New Jersey doing away with it.
Okay, so,
New Jersey administrative, it used to be more complicated before they did away with it. When 10 years ago, New Jersey estate tax was $675,000. So we used to have to do a lot of sophisticated stuff. And now, some people have, sometimes we would do clauses where two people would not give it to each other, set up testamentary trust, but that's a little bit, more than we can go over in the next 2
so
minutes.
regardless of whether or not you have a will or a trust, there isn't any estate tax or inheritance tax.
If it's going to inheritance tax, if it's going to brothers or sisters, the first 25,000 is tax-free. After that, the tax is 11%.
In a will and a trust.
Either way, because of revocable trust, the person's still deemed to have it. If it's going to anyone else, the tax is 15%, but that's what it is. Okay, I gotta move on and talk about powers of attorney, okay? What a will takes care of your assets if you pass away. What a power of attorney does is you're giving the ability to someone who you trust to be able to pay your bills, act on your behalf legally. Let's see. I mentioned earlier, just because someone's married, the spouse really doesn't have legal authority to do anything. So, a power of attorney is recommended. It doesn't have to be the spouse. It could be one of the kids. You have a number one and number two. There's one captain of the ship, not two captains. One of the things, some of the banks weren't honoring perfectly good powers of attorney. So New Jersey legislature came out with a statute that says, if it makes reference to the New Jersey statute, then the bank has to honor it. However, it has to make reference to the New Jersey statute, section 2 of PL 1991, C 95, C 46.2B-11, and the free forms you might find online don't have that, and they say just because they say on their website it's valid in every state, a lot of banks won't honor it. Now we also recommend that a will is good from when you sign it. It's good in any state. Will never expires. There's no statute that says in New Jersey how long it's good for. So we usually recommend people sign a new one every 5 years or so, or if people's names change or addresses change. Okay. The power of attorney is effective either right away or only upon disability. If it's effective right away, it's called a durable power of attorney. It stays in effect even if someone becomes disabled. A springing power of attorney only springs into effect if someone becomes disabled. Let's say Mr. X said, Kenny, I don't understand this legal stuff. Let's say springing and door. He goes, I'm a carpenter, explaining carpenter language. Okay. Fred, I go, if it's effective right away, your son, who is your executor, can steal all your money right away. If it's only effective upon disability, he has to get a note from a doctor before he steals all your money. Knowing that, you trust your son. He goes, oh, I trust my son with my life. Okay, then make it effective right away. Don't make it more difficult for him to have to get proof from the notes from doctors, etc. The last document I'm going to talk about is the living will advance directive. There's been so many great things that hospitals and doctors have been able to achieve, but then there comes a point in time where the mind is gone, and so what the living will is where you're giving instructions to hospitals and doctors what your wishes are at the end. And the document really isn't for you because you're the one that you can no longer talk. You know, you're lying in the bed. It's to take the trauma off your family so that the doctors don't have to ask the family, should today be the day? Because I remember when a doctor asked me that, and it wasn't even a family member. I was their power of attorney, but I remember saying to the doctor, geez, I feel bad about saying yes. Now, I know the right decision was for someone who's 92 years old, but, you know, I mean, I couldn't even make the decision when my first dog was like, you know, sick and at the end, after we spent $16,000 on, you know, dog surgeries and treatments, you know, so what your living will is, you're giving instructions to hospitals and doctors. Listen, I'd say, if there's no hope for me, I don't want to be on machines, etc. And then, you know, you don't want to have artificial, feeding tubes, you know, respirator. Now, we're not talking about if someone has a heart attack and, while they're buying grapes at ShopRite. It's where the doctor says, listen, there's no hope. We can keep the heart going, but the brain isn't going to come back. So, you know, the idea is do it now. And some people have someone different than their executor for the living. It could be someone who has more knowledge on medicine, or sometimes someone that they know that they could talk. They'd be more comfortable talking to the doctors. The last time when you're first married and you're all lovey-dovey, and my wife and I were redoing our documents 34 years ago, and my wife said, I could never let them remove life support from you. I go, okay, fine, I'll just leave my dad, because he's logical like Mr. Spock. Okay, Kenny says, no one is, okay, that one. So then 25 years later, the kids are out of college, and we're updating documents, and she says, so, if you get dead, I get $850,000 tax free, and I don't have to work anymore, and I can quit my job. You know, bonus. You know, let's put them down now. So so I went over my time. I didn't have my buzzer on, but Brandon, why don't you come up and talk for a little while about finances?
I have a few things to
Can I ask one more question?
I'm gonna see you now.
Quick question.
Yes.